The GENUIS Act has been officially signed by President Trump, and if you're a stablecoin issuer, the 18-month clock is ticking to make the required critical changes to comply, or risk being pushed out of the US financial system altogether. This new law creates a strict oversight regime that determines who can and who can't issue stablecoins. At TNF, we work with stablecoin issuers globally. Our clients are already calling and asking, how does the GENUIS Act impact our company? Well, stick around, because by the end of this video, you'll understand exactly what's changing, how the new oversight regime works, and what you need to do to capitalize on the biggest crypto-related legal change in US history. Welcome to TNF Takes, the go-to spot for crypto companies and on-chain organizations. Before we dive in, make sure you like this video and subscribe to continue getting top-tier content for your crypto company or on-chain organization from industry experts who have been around the block. I'm Noah Buxton, and I'm here with my partner and co-founder from the network firm. We're here to help you establish trust, build efficient crypto operations, and stay ahead of the curve in an ever-evolving industry. The GENUIS Act, or the Guiding and Establishing National Innovation for U.S. Stablecoins Act, has been a long-awaited regulatory clarity that the crypto industry has been seeking. But is it all sunshine and rainbows? And what do finance and accounting leaders need to know to prepare? While the GENUIS Act is a regulatory step forward, it comes with new and a somewhat complex oversight structure, demanding reporting measures and a strict set of compliance requirements, some of which are yet to be determined, and all of which will need to be adhered to in the next 18 months or sooner. So let's first cover the activation timeline, the key concepts of what a quote-unquote payment stablecoin is, the governance and oversight aspects of this law, and who can issue payment stablecoins in the US. Jeremy?
Noah, thanks for having me. Huge change in the U.S. regulatory landscape. As you mentioned, there's a lot of changes coming, and everyone's been waiting for this for years now. And these changes are going to be happening very quickly. So the bill, the GENUIS Act that was just signed by President Trump, goes into effect within 18 months of signing, right? Or it can actually happen sooner if the federal regulators issue and finalize the required rules. Once that happens, the act actually comes into effect within 120 days of that event. So it's either 18 months as of last Friday on July 18th, or 120 days after that these rules are finalized at the federal level. So, what does this GENUIS Act do? Well, the first thing that's important is that it formalizes a key concept, and that's the concept of a payment stablecoin. And, what is a payment stablecoin? We all know of stablecoins, dealing in crypto, but what is a payment stablecoin? Well, the Act has a strict definition of what that is. It is a digital asset that is or designed to be used as a means of payment or settlement, and the issuer is obligated to convert, redeem, or repurchase for a fixed amount of monetary value. So that also, those issuers represent that token will maintain, or they've created a reasonable expectation that that token will maintain a stable value relative to a fixed amount of monetary value. So that's a lot of jargon in the bill. It's a little bit of legalese. So what does that actually mean, right? Is a US denominated dollar token issued by approved entities, back one-to-one by permitted reserves like cash or T-bills, government securities. But it does exclude certain things. What is not a payment stablecoin? A payment stablecoin is not a crypto collateralized stablecoin like USDS or formerly DAI, or even RWAs or bridged assets or wrap tokens. So UBTC, is not a payment stablecoin, right? It's not, backed by, or it's not denominated in a fixed monetary value of, a US dollar, for example. It also excludes national currencies. So let's say in the future, a country issued their own CBDC, right? That would be excluded if it was classified as a national currency by that country. So that's really the key, is understanding, first off, what is a payment stablecoin? And that will be the impetus or the foundation of all the rules and regulations that come from this bill.
The other thing that jumped out to me with that word payment stablecoin, it's almost like a quick wording way to say not natively yield bearing, right? So the issuer, right, doesn't offer either a mechanism, a smart contract based or logic based mechanism to offer yield. It's not sort of accruing yield natively. And also, holding stablecoins in the account of the issuer, you're not offered yield on sort of a more traditional calculation. I think that's important. Like these stablecoins are they're payment and settlement, like you said. Certainly, secondary markets and DeFi, they still would be. They're not prohibited, to be used. There's no prohibition from using them to earn yield in those sort of marketplaces. But natively, they are payment and settlement, not yield bearing.
Yeah, that's a good point. And then the next thing that this bill does is that it creates the foundation for the governance and oversight structure. Effectively, who's in charge of this whole system? So at the top of this pyramid, we'll call it, is the Certification Review Committee, which serves as the overarching governing authority of this whole new system. So there's a committee of 3. This committee is chaired by the Secretary of the Treasury. So that would be Howard Lutnick at this time. And on this committee, there's 2 other parties, the Federal Reserve Chair and the FDIC Chair. And in certain instances, where they'll be making rules or making determinations, are required, 2 of 3 vote is required to approve. And in certain instances, unanimous approval is required too. And the certification committee, review committee, oversees the different pathways that stablecoins could issue under, right? There's the federal pathway, the state approved pathway, and even a pathway for foreignly operated stablecoin issuers seeking US market access. So these are the prongs, these are the different pathways that parties can issue under. And this can include, right, banks, this can include credit unions, this include crypto native stablecoin issuers. All of them would fall into one of these pathways, depending on which oversight regime they're looking to achieve and certain characteristics about the stablecoin issuer.
Awesome. Yeah, let's dig in a little bit more about sort of who can issue. As you mentioned, there's this certification review committee, and ultimately they will have to promulgate more rules, more clarity in this process. But right now, on the text of the bill, the text of the new law, there's definitely those that we can say are not permitted issuers. So, you may be working for a business right now that has a certain model or sort of fits into this category. And so this would be, sort of urgent changes. If you still want US market access, you want to be a US stablecoin issuer. If you fall into any of these buckets of non-permitted, you want to probably make big changes and make them quickly. And then we'll go into the federally qualified payment stablecoin issuer, the state qualified issuer framework, and then maybe just a quick note about the foreign issuers too. So non-permitted issuers, so yield-bearing tokens. I already previewed that one for you. If you're natively yield-bearing, again, by smart contract, by code, so to speak, or by sort of a more traditional way that people, customers can hold an account with you, not permitted right now. Companies who do not have an existing financial related service, like such as retail, SaaS companies, or tech companies, and any company with financially or persons, directors of a company who have a financial related felony as deemed in the act, cannot serve as an officer or director for an issuer. Now there's this federal pathway and there's this state pathway. And so this hierarchy is interesting. We should talk about sort of the preemption aspect. Like at the end of the day, what does it mean for the vast majority of issuers? Because the federal qualified payment stablecoin issuer pathway is really a very limited number of issuers in the market today. But if you rise to the level of being under the federal oversight, you have to be US domiciled. And this can be, again, a native a crypto native issuer, can also be a bank or a non-bank entity. And these are sort of big stablecoins. So this is over 10 billion in issuance. They can be GSIB banks, credit unions, subsidiaries of credit unions and banks likely fall in here. And again, they need to be federally approved. Specific applications and requirements are just yet to be defined, but this is what the certification review committee will determine. And then on the state pathway, there's a lot that's interesting here, but I'll try and just get out the basics first. So yeah, domiciled in a US state, here again can be a bank or non-bank entity, must be under 10 billion in issuance. And again, that's the vast majority of stablecoin issuers today, and has to operate under a state regime deemed comparable to the federal rules. So the current system, as you know, those of you working for stablecoin issuers know, is effectively the 50 state money transmission laws that are a flow down or a result of the Bank Secrecy Act and the requirement for BSA compliance at the state level. We don't know yet today. Actually, this is a big open question. And so you can mark this as a checkbox to be filled on your list here is, okay, what is a comparable federal rule? What is a substantially similar state MTL regulator rule set that is, you know, again, that the feds will say, that CRC committee will say is substantially similar to their federal framework. These will eventually be published on the Treasury's website per the bill. And the states are going to be subject to a yearly state review as well, and an approval process by that certification review committee. If you're state approved in that state approved level, there's going to be specific applications and requirements that also need to be defined. So again, a lot to be determined here, but generally speaking, there's this two-tiered system to begin with. If you breach that 10 billion, you're transitioning into federal oversight within 1 year of reaching that sort of market capitalization threshold.
And I was going to say, yeah, it's really interesting, right? Like usually as a stablecoin issuer, you're worried about being approved or being compliant where you're, you know, either your state or federal pathway. But interestingly enough, the state jurisdictions, the state regulatory regimes actually have to be approved at the federal level, and those will be posted on the website of the Treasury. So they actually have their own certification process that needs to be adhered to, and that has trickle-down impacts on stablecoin issuers. For example, let's say you were issuing under your stablecoin under a certain state, and then a couple years down the road, that state's deemed to be inadequate, right? You might be SOL in this case, right? There is opportunities for state regimes to cure and fix and remediate as necessary, but you are really, you know, riding your wagon on a certain state that you issue out of. So definitely want to make sure that you make the right decision there, the state that you issue out of, if you're choosing this pathway.
Yeah, and this is a big change. I just want to spend a little bit more time here because this deals with this federal preemption concept, right? So right now, if you're working at a stablecoin issuer, you're determining your go-to-market strategy and your compliance strategy and execution. You're dealing with a 50-state patchwork, and you're probably working through the NMLS, the National Multi-State Licensing System, which attempts to create sort of a unified pathway to get, you know, to all the different state requirements, right? How can you apply sort of in a relatively condensed way to get, you know, ability to offer stablecoins to citizens of individual 50 states? Right now, it seems like this is really it's a big change, right? I think the good part of the change is it's, you know, from what we're reading right now, from what we know, it's that these newly the state regimes that are approved as substantially similar to the federal regime, an issuer will just have to be U.S. domiciled and registered with one of those states, and then have effectively what I call a passport. So there's no more of the 50-state patchwork requirement when it comes to stablecoin issuers and money transmission. I think this is a huge change. It definitely streamlines compliance for sure. I think you bring up a great point, though. Around the corner, it brings up those risks as well. You've sort of, you know, you've hitched your cart to one state. If that state doesn't maintain substantial equivalence with the federal regime, that could cause a big disruption if it wasn't cured timely by the state itself. So huge change here.
Yeah. What was interesting too is I know there's also a path for foreign issuers that people were worried about, you know, what's going to happen to the foreign issuers, or Tether in this instance. So the act actually calls out specific requirements for foreign issuers if they want to be able to offer stablecoins in the US. So this is relevant for issuers not domiciled in the US, and that includes US territories. They're considered foreign. For example, Guam, the Virgin Islands, etc. So those aren't counting as the US in this instance. So in this case, if you're a foreign issuer, you have to hold all your reserves in US financial institutions. You can't have any sanctioned ties, and you have to get explicit approval from the Treasury and the comptroller. Now, if you operate under a foreign regime deemed comparable to the federal rules, then there's kind of this reciprocity aspect, almost like at the state level, right? If a state is deemed substantially equivalent to the federal level, well, also foreign jurisdictions can be deemed substantially equivalent to the foreign level or to the federal level, and those will also be published on the Treasury's website that are deemed comparable, and you can issue under from those jurisdictions as well. So there certainly is a pathway, but it does come with more requirements, right? If you're a foreign issuer, such as holding all your reserves in U.S. financial institutions, which is a big one. For example, for Tether, in this case.
Yeah. At the end of the day, when I look at this one, I think, is there really a foreign issuer pathway? Or there is, but does it really mean that a foreign issuer essentially needs to become in some part a U.S. issuer? They need to have a U.S. subsidiary. They need to hold really what it comes down to is holding the reserves in U.S. financial institutions. I think that's the big change for like what would be a foreign issuer if you looked at them today, right? Would be a mix of maybe some offshore custody, some in their current jurisdiction custody. And so that's a huge change. It would require a lot of corporate reorganization to truly become a foreign issuer.
And they do have to comply with a lot of different oversight and examination requirements that would flow through down. Basically, you're being overseen by the federal regulators in the US, right? Even if you're a foreign issuer, technically, if they ask for information, if they ask for BSA, all these different things, you're going to have to comply with those requests. So, effectively a US issuer, even though you're technically foreign domicile.
All right, so let's get into more of the details of the actual requirements. But before we do that, let's note that this bill also includes pretty significant and clear fines and penalties. Anyone a director of a company, associated, sort of ultimate beneficial owner, a felon with a felony conviction trying to issue a stablecoin, $1 million fine out of the gate, plus criminal charges, not civil penalties, but criminal charges up to 5 years in jail. Pretty clear criminal requirement there. And an approved issuer that has gotten a cease and desist or a non-compliance notice, here again, likely from the federal regulator, can accrue a fine of $100,000 a day. So pretty steep penalties. Let's talk about the requirements that ultimately the compliance or non-compliance are going to be measured against. So, well, the big one right at the top, reserve requirements. Something we've been talking about for a long time. When do we do our first, as practitioners, Jeremy, when do we do our first stablecoin attest engagement?
Probably 2018. And of course, the big thing with stablecoins is maintaining a 1-to-1 reserve, right? For every stablecoin issued, you have to have $1 or equivalent in reserves, right? That, of course, is staying here. No fractionally reserved stablecoins are allowed.
The other big requirement here, it's just, really draws down the scope of what is a qualifying reserve asset. This has been, I think the market has somewhat determined this. I remember early on in the space, there were certainly issuers that were US, definitely, fiat backed. But the scope of the reserves basket was pretty wide, or could be wide. It wasn't regulatory determined. I don't think state regulators really have the tools or understanding to narrow that scope for issuers. And so you would see things like, yes, maybe US Treasuries and overnight repos, et cetera, and cash. But you'd see things like corporate bonds or fund holdings or longer term Treasury holdings, right? Longer maturity Treasury holdings. And so here's the key points. It really draws down that scope. So physical US currency, we had a chuckle at this one. Yes, US coins and paper currency held in the bank vault. In the real world, in the modern world, right, those are deposits or accounts held with financial institution that are dollar accounts. It does cover demand deposits, so funds held in checking or equivalent accounts. Noting here, there's not a trust account requirement either, but the reserve qualifying reserves can also include short-term U.S. Treasury securities, 93 days or less on the remaining maturity of those notes. So they could be longer term T-bills, but remaining maturity 93 days or less. things like repurchase agreements, overnight repos, or repo agreements are acceptable as reserve assets, but must be collateralized by U.S. Treasuries with, again, maturities 93 days or less, and government money market funds, which is, a great way for a corporate to get access to, an account that has a yield-bearing aspect to it. It's an easy entry instead of managing securities yourself, let's say. It's an easy way to say it. But these money market funds is sort of a level down, must only invest in the assets listed above, right? So they have to be money market funds invested in Treasury securities with 93-day maturity or overnight repos. So money markets are okay, but have to meet those requirements above. And other similar instruments. So there's a catch-all bucket here that does allow the Fed to say there could be other qualifying reserve assets, but right now, that's the set. The other interesting part, which I like, that's very crypto, is that theoretically there could be approved assets that are tokenized reserve assets. So as long as they meet one of the qualifications we just went through, but they're a tokenized version of it, theoretically, those are qualifying reserves. So that's kind of cool in a crypto sense. Yeah, I think there's some interesting things about that, right? So some practicalities to that, but yeah, that's what we got on qualifying reserves. So drawn down.
Yeah, we see those tokenized money market funds come up. Like if they have the required composition, those could fulfill the requirements, which is pretty unique and cool.
Right. Yeah, I won't go down that rabbit hole, but it's super interesting. Let's talk about the transparency requirements. This is our bread and butter. This is what we think about every day. So let's hit the high points, and then maybe there's a couple interesting nuances that folks would want to hear. So you want to cover that?
Yeah. So first thing, clear redemption and minting policies. So that includes timelines for redemption and for purchasing, right? When are you going to actually get the fiat or the tokens when you do a transaction? And you need to publicly disclose the fees associated with minting and redeeming. So typically we see this in the terms of service of an issuer available on the website, right? So they have to be clear and conspicuous. Next, you have to publish your reserves monthly. So that includes the amount of the reserves, the composition of the reserves, the tenor, and the geographic location of those where those reserves are held. And then, of course, with that comes the monthly examination by a PCAOB registered auditor over that subject matter. So effectively, you get a monthly attestation where this has, largely been adopted as the industry standard, but the independent accountant would come in and verify the amount of holdings, the type of holdings, the maturity of the holdings, and ultimately the fair market value of the holdings within your reserve basket. As part of that, there needs to be a monthly certification by the CEO and the CFO submitted to the state or the federal regulators that the information is true and accurate. Oftentimes this this practically happens when management signs management's assertions and representations related to that independent monthly accountant report. And there's also, this monthly reserve attestation, but there's also an annual financial audit requirement. So this is actually a difference between there's some differences depending on how big you are as a stablecoin. So if you are under $50 billion, you can get a private company audit. So it doesn't necessarily need to be under PCAOB standards. And there's no requirement to publish those independent financial statements publicly. However, if you are over 50 billion, effectively you're getting a public company type of audit where you have to get that audit under PCAOB standards and your published financials have to be published publicly, similar to a public company, really. So everyone's going to see the financial health of your company, not just the reserve basket. So I thought that's a unique characteristic of this as well. No, there are a couple other requirements too on the transparency measures. Do you want to hit those?
Yeah, sure. I think there's an open door, to transparency, meaning that issuers of any size are really subject to examinations from Fed and or state level regulators. So it kind of brings in this bank level examination requirement. Look, if you work in legal or compliance or even finance at an issuer today, you know that you're really always subject to some level of government inquiry, whether through subpoena or other less formal engagement. But this makes really clear that there's sort of examinations are on the table. And so I don't think we know what this looks like exactly, but this probably, again, is in the purview of the Certification Review Committee as to establish, first, what are the broad-based standards that make a state level regime substantially similar? Like what are the rules of the road? And then they can examine against those. And we don't know if is this surprise examinations or these scheduled examinations, but generally, yeah, this makes very clear that that's possible. The other requirements regarding transparency or sort of features of transparency in the bill, one of them really jumped out at me was around the commingling of customer and company assets in an omnibus account. And it's okay under the bill. Yeah, I'll say that again. Commingling is okay for convenience, for fees, for settlement, for taxes, etc. So really, effectively, any legitimate business purpose that the company's making transactions, it's okay to put customer or token holder funds and company funds in the same account. So the key distinction here is, yes, commingling. I could talk all about that, but the key distinction here is that yes, commingling is allowed. However, the bill also does set out, bankruptcy or liquidation situations where stablecoin customer redemption claims, essentially, they get priority. So I think that's a good feature. I frankly don't like the commingling aspect at all, but I think we would recommend anyway that. We should talk a little bit more about this, but it's actually still, it might just be a bad business choice. It might create more compliance costs, more internal operational costs, less internal oversight capability, insight and oversight. So I just don't see why you would do this, frankly, because I don't think there is necessarily a lot of convenience that outweighs the other costs.
And my thought when I was reading the bill is that it's probably more for on the bank side, right? Because they, ultimately they have, like how they have demand deposits today is that they have demand deposit liability, and the underlying assets, they're not segregated by customer. They're basically just investing in treasuries or giving out loans, etc. So this is probably made for the banks, I would say, for the most part, because they don't have this segregation structure like in their underlying assets that back those demand deposits. And I know demand deposits are excluded from like being stablecoin in this bill, right? That's not what this is about. But that infrastructure is similar to probably how they're going to be issuing stablecoins. So that's my take on it.
It's not a bad take, but I think the bill is also saying if you're a bank issuer, you're essentially doing it through a subsidiary, right? So it's not US Bank NA, it's, US Bank Stablecoin Services Inc., whatever, And so in that case, I feel like if there is that entity distinction, that commingling issue isn't as direct, meaning, US Bank, Stablecoins Inc. or whatever can hold an account with US Bank NA, and it could do a segregated account or a commingled account. I think, it sort of still applies. Anyway, I think it's an interesting one because if it is, let's say, a bank-driven or sort of leniency, it's also an area where the market has seen repeated failures, right? It increases the risk of mistakes, sort of benign mistakes, but that are impactful. It increases the risk of fraud. It reduces the oversight internally and insight internally. It also makes a regulatory examination more costly and more difficult. It's going to make your audit more costly and more difficult. The auditor is now going to, when they look at, let's say, the single account that holds all customer reserves, but also all company assets, and record, and the statements from that bank, from that account, are now including all mints and mint deposits and redemption withdrawals, and also all company transactions for G&A expenses and payroll and the whole thing. Just going to make things more costly. So that would be a strong recommendation. It's like, sure, you can, but you shouldn't anyway. So there's some other requirements. This definitely includes the existing Bank Secrecy Act, AML, so anti-money laundering and terrorist financing, the know your customer requirements, generally referred to as AML KYC, but obviously includes a whole program aspect, still a requirement. And interestingly, they were very clear about like functions in the stablecoin operation and or smart contract for freezing, seizing, blocking transactions is required. So they want to see not only that you can meet a certain regulatory standard, but that you also can take effect to ensure your compliance program, right? For sanctioned individuals, et cetera. You got to be able to freeze those accounts.
Yeah. Yeah. And there's a couple no-nos, right? What things can you not do? Well, the first one that was interesting is that the naming of your stablecoin, or the ticker symbol of your stablecoin, you can't use U.S. government or United States in your stablecoin name, or USG in your stablecoin ticker symbol. So you can't call it USG1 or US government stablecoin XYZ. And you can't say that it's backed by the full faith and credit of the US government. So, but you can say US dollar, USD is okay. So I think a lot of stablecoin issuers are breathing a sigh of relief. USDC, USDT, USDG, they're all okay. But for new issuers out there, yeah, keep that in mind as far as the terminology that you can use. Next, you can't actually have a non-compete agreement when you're trying to sign up someone to purchase your stablecoin. So if you're USDC, you can't have in your terms of service, by purchasing USDC, you will not use USDG, for example, right? The non-competes are not allowed. And you can't also force the use of your stablecoin on your platform. So if you're, some sort of platform and their services on your platform, you can't force your users to use your stablecoin as a precondition to use services on your platform. So all in all, I think these are actually pretty good and reasonable and relevant for a healthy stablecoin ecosystem.
Yeah. Yeah. And just to cap it off, again, there is a pretty clear and pretty significant fine or penalty structure, including a criminal aspect here. All of those things are at play. And as you said, the clock is ticking. So there's things to be figured out. There's open questions and rules yet to come. But I still think there's a couple unique elements, right? So we've gone through the requirements. Let's talk about a few other unique elements, things that we think our, CFO clients and finance and accounting pros should be thinking about. And I think then after that, we can put a bow on this thing. So custodial services. So if you're offering custodial services for stablecoins, such as custody of your customer stablecoins, this is essentially an okay practice, generally speaking, under the text of the law, right?
Yep. Yeah. I mean, that's pretty important because a lot of these stablecoin issuers, people will purchase it, but maybe they're less crypto native. They don't want to get the stablecoin sent to their own self-custodied wallet. Well, you can simply have an account with the issuer and have a US stablecoin denominated balance on these platforms. So makes sense. But of course, the custody infrastructure certainly must need to be enhanced for these companies now, because you're not just issuing and redeeming, you're actually holding stablecoins on behalf of your customers.
Yeah. Yeah, another unique element I'll stuff in real quick is like it's a bit of again there's a big sea change here to essentially a federal preemption framework. Allowing yes to be a state and substantially similar. You can be in the state regime, but again, it has to be effectively substantially similar to the Fed. So it's really a federal regime at the end of the day now, through and through. And so, and meanwhile, we have sort of a market developed self-regulatory set of best practices and themes and commonalities around what are companies and issuers doing for the attest reports, right? These are really customer transparency wants that have been translated into monthly attest reports, right? Or even the real-time attest reports and transparency that we've done. So but what is good enough at the reporting level? I think that's a very unique, very specific thing to be determined. And to be clear, it's definitely saying you need the opinion of an auditor, of an audit firm, right? And it has to be to the examination standard, right? So it has to be the opinion examination level engagement. But that really has two components to it, right? It's got sort of the CPA's letter, the independent accountant's report. Hey, we did this, we opine this, right? And then it's got the second part, part, which is opining over what? You're opining over management's report and the subject matter there, the balances, and the assertions that management makes. You're testing those assertions to reach that opinion. So, but what's good enough within the four corners of that second part of the report? I think that's to be determined, right? Because there's a relatively wide disparity right now of how issuers present. And so I wonder if that's going to come in here with the rule set. I think that's to be determined.
Yeah, right now it's pretty broad in general as to what they outline, right? It has composition, it has tenor, average tenor, and geographic location. But many reports out there today, we see a whole lot more information or different information, right? So it seems like it's actually pretty limited scope right now, but I think once we see the actual final rules, we'll see the the details of that in a little bit more context, which will be helpful.
Yeah. Yeah, one other thing I think about real quick, sorry, as a unique element that maybe finance pros should think about here at CFO level is like the bill to me is not very clear about the two levels of customer types, let's say, or user types, and what management's responsibility for compliance is at certain levels or reporting is at certain levels. Like, so to be clear, there's this onion, right? There's the issuer in the center, and the first layer of the onion is direct customers of the stablecoin issuer, and they have terms and conditions, contractual privity with the issuer, and they have in those terms a right to redeem, right, a stablecoin for the fiat equivalent, the dollar. And then there's the second layer of the onion out, which is token holders, is the way I think of it, right? They don't really have a contractual relationship with the center of the onion. They don't have terms and services necessarily that apply to them, unless there's TNCs that say by holding you at least confirm you're not using it for illegal purposes or whatever. But otherwise, not a right to redeem is the important part. And so when it comes to the reporting, will CPA firms, for instance, have attest reporting that is willing to make the end token holder an intended user, right? Can those token holders get assurance that over the stablecoin reserves, or are they sort of excluded from taking assurance on those reports? It's a nuanced like accounting attest issue, but I think it's pretty important because ultimately the end token holders, I think today probably are largely taking assurance, even if they're not marked as an intended user in certain reports.
Yeah, practically, right? They're made public. They're looking at them. If they're not getting assurance from them, I don't know what they're getting at all. There's a couple other unique elements too in the act. So it actually does define payment stablecoins as not a security or a commodity. So it does amend like the SEC Act of 33, 34, the Commodities Exchange Act to remove payment stablecoins from the definition. This doesn't remove things that are not payment stablecoins, right? But anything falling within the jurisdiction of this act is removed. It is technically and functionally not a security. So hopefully some issuers can sleep a little bit better at night about that in the future.
Yeah, that's probably the heart of the regulatory step forward, right? Is that there's like this, there's a spot for stablecoin issuers that's clear now.
Yep. And we briefly touched on it earlier, but issuers must have like a financial related arm, or this is their primary activity. So if you're Amazon or you're Facebook or you're Google, where this isn't your primary operations, you're not allowed to issue stablecoins, which is actually pretty interesting. I know a lot of, of course, there was the infamous Libra in Facebook. So if that was to try to go forward ahead today, that would not be allowed, right? Because that's not their primary business line. So that's going to scope out a lot of other types of companies looking to get into the stablecoin space, for better or for worse, honestly. So
what about Starbucks? Take an opinion. Can Starbucks
would be
stablecoin?
No. I would say no. PayPal's interesting because they are financially related, so I think they're going to be fine, right? But
yeah, I agree with you on PayPal. Starbucks is interesting though, because in a way, like Starbucks sells coffee, but they also hold Starbucks accounts and credits for users, gift cards, etc., mobile gift cards, right? That are like on a size of deposit basis, like far bigger than even sort of your average medium-sized bank, right? It's been a while since I've looked at these numbers, but it just came to mind. But they're huge amount of money that they essentially manage for app users. So in some ways, they're kind of a financial intermediary too.
Yeah. Where's the line? We'll let the the committee, the certification review committee.
I'm sure Starbucks can afford the lawyers to make the case, but yeah. And then I think there's this idea in the law to another unique element. This sort of goes to the consumer level in a way, but self-custody, transfers to self, these are kind of called out specifically and excluded from the scope of the requirements, right? So how do you read that?
Yeah, I mean, I think what they're trying to do is offer protections or clarity or comfort to token holders, stablecoin token holders, that, hey, if I send stablecoins to my self-custody wallet, which was actually referenced in the act, that's okay. Or if I'm sending to someone else overseas, that's, not the issuer or not anyone else, that's okay, right? You can use stablecoins how you're typically using stablecoins, which I think is a great point of clarity and removes a lot of anxiety for token issuers and token holders from the scope.
The other thing for our CFO and finance pros that's, I think, a unique element here, and is really important from a financial accounting and management accounting perspective, is the bill is pretty clear that, let's say you're not the issuer, right? You're a platform operator, you're a hosted wallet provider, you support payment stablecoins. Let's say they're approved payment stablecoins are on your platform. This kind of goes back to our SAB 121 days, right? But it's effectively, you do not have to hold a safeguarding liability you don't have to hold a safeguarding asset in conjunction with a safeguarding liability for your customers' stablecoin deposits. So I think that's good clarity for companies that have essentially deposits, custody of customer stablecoins, for the offering of exchange or sort of other custody purposes.
Yep. Yeah, I think that's a big point of clarity for the banks for sure for this.
All right. Well,
yeah.
I was going to say there's a ton yet to be determined. So I think we'll come back and we will help you monitor this space. Obviously, we have our finger pretty close to the pulse here on these changes. But I think, what do you need to do now? Well, first, subscribe to TNF Takes if you haven't, because we're going to keep our finger on the pulse for you and come back with some insights and some breakdowns like the one we did today. But hitting it quickly, I mean, it's determining your pathway. It's monitoring for specific, application requirements as they come out, which again, once they're finalized, can trigger that 120-day window, right? So it could be before 18 months. So definitely monitor. Really take a close look at your audit and compliance function, how the business is reporting today. And ultimately, we'll ask you to reach out to TNF if you need any help, any insights, or if you want to get ready, or if you are ready and need to talk about that attestation and or that audit requirement. So I think that's what we recommend as sort of next steps. What do you say, Jeremy? Any parting shots?
Nope, I think that's it. Yep, certainly keep your finger on the pulse to this because it's going to be moving quickly. 18 months or the 120 days is going to expire quickly. So need to start now to make sure that you're ready.
All right, my man. That's been another TNF Takes. Thanks, everyone, for watching. Hopefully you found it useful, and we'll see you on the next one.